Good morning, and thank you for joining us on this rainy Friday. My name is Scott Pacheco with Lerch, Early and Brewer. Today's webinar will feature Lerch Early employment attorneys Marc, Engel, and Mike Neary addressing employment issues related to COVID-19, including remote work, leave, and taking a look at what the new normal will look like. Before we get started, I have a couple housekeeping items. This is a listen-only presentation, so you will not be able to verbally ask questions. So you also do not have to mute your phone, so that's a benefit. But you can send in questions through the chat feature, which I will be monitoring throughout the webinar. The plan is to stay within the allotted hour, but if the Q&A does run long, we may go longer. This presentation is being recorded, so if we do go long, if you do have to drop off at noon, you'll have access to the recording and any additional content that happens after that point. I'd now like to introduce Jane Redeker, President and CEO of the Greater Silver Spring Chamber of Commerce, one of the sponsors of this presentation, for some opening remarks.
Good morning, everyone. Thank you for joining us this morning to learn more about some of the issues that employers are facing as you manage your operations and your people through this COVID-19 crisis. I also want to thank Janana Taliano of the Greater Bethesda Chamber and Marilyn Balcom of the Gaithersburg-Germantown Chamber for co-sponsoring and hosting this event with me. On behalf of all three of our chambers, though, I want to thank our presenters from our joint member, Lerch, Early and Brewer, for taking the time this morning to provide their expertise on some of these concerns. First, we're going to hear from Marc Engel, an employment attorney who is an expert on a myriad of employment issues, including federal and state wage and hour laws and Family and Medical Leave Act. He's a sought-after speaker on best practices for these and other issues, and we're fortunate to have him with us this morning. Joining Marc is Michael Neary, also an employment attorney with expertise on the Family and Medical Leave Act and other workplace issues. He routinely defends employers in court and also helps clients avoid litigation through counseling and training. So this morning's presentation promises to be engaging and very useful. So Marc, without further ado, let's get started.
Okay, thanks very much, Jane and Marilyn and Janan. On behalf of Mike and Lerch Early, we really wanted to thank you for sponsoring the webinar this morning, and I want to thank all the participants from the chambers, for your time this morning as well. So let's just jump in and get after it. I'm going to be discussing remote work issues. The order of the day is that Mike's going to follow up with discussion of some other employment-related issues, including some leave issues, a discussion of furloughs and the ADA, and then he's going to turn it back to me. I'm going to be talking about returning to the new normal. And then we'll have time, as I think Scott mentioned and Jane mentioned, for questions hopefully near the end, and we'll certainly happy to stick around for a few minutes after the presentation to address any questions that you may have. So COVID-19 has really effectively required employers to consider remote work alternatives in a way that they probably haven't had to do in many, many, many years. But any decision to move or have employees, work on a remote basis, regardless of the size of the employer and regardless of the number of employees, really does require a myriad of decisions and considerations. And I'm going to address those this morning. Each of the topics that we're going to discuss this morning really could lend themselves probably to an hour discussion. But what we're really trying to do here is to give you the highlights, some of the best practices, and some what we think are some effective strategies and action items for next steps. But let's talk about the basics for just a second, and let's kind of make sure that we're using the terms in a way that makes sense to everybody. Remote work is a generic term. Some folks use the term telework. But essentially, it's an alternative work arrangement, often from an individual's home, but it can be elsewhere. When we return to working on site, it can be at a client site, it can be full-time, it can be part-time, it can be for a short period of time, it can be for a longer period of time. One of the overarching themes to keep in mind that as a general rule, working remotely is not a right, but rather a privilege. Now again, I'm going to talk about remote work issues in phases. We've heard a lot about phases and phasing in from the federal government, and I think it's an interesting paradigm for looking at the remote work issue as well. We're certainly in a situation now where remote work is effectively being compelled because of the stay-at-home orders, the shutdown orders, and so forth. So it begs sort of several questions. Can employers require or encourage employees to work remotely in response to COVID-19? And the answer to that is essentially yes. But an answer to that also really does require an understanding of the American with Disabilities Act for reasons that I'm going to discuss in a little bit more detail, and Mike will get into a little bit more discussion, greater discussion later. Under the ADA, employers can exclude employees with disabilities from the workplace when they pose a direct threat to themselves or to others. And again, as I said, we're in a situation now where remote work, except for essential personnel, is really being required. The flip side of that question is can employees request to work remotely? And again, less of a consideration right at this moment as we speak, but it'll become more of an issue in the weeks and months ahead, hopefully much sooner rather than later, when we hopefully have a phased-in return to work. And the short answer to the question is whether employees can request to work remotely is yes. They can request it as an accommodation under the American with Disabilities Act and the local and state laws if they've had an exposure to COVID-19, they have symptoms, and more recently under the emergency federal statute, the Families First coronavirus statute, which has an emergency paid leave piece to it and an emergency family law leave piece to it. But the key thing to keep in mind is as we start to return to the new normal is, employees there's going to be a discussion about whether employees should return to work, whether it's necessary for them to do so, whether it's safe for them to do so, and quite frankly, whether they want to do so. And so these are some of the issues that are going to be up on the horizon, I think, in the weeks and months ahead. In terms of the ability of employers to require employees to work remotely, particularly if they've had an exposure to COVID or to family members, yes, that right exists on behalf of employers, and usually the foundation for that is looking at guidances from the CDC, guidances by state and local authorities about when and under what circumstances people can be required to work at home when they pose a danger to themselves or to others. Mike and I are getting a lot of questions about, in various forms and various shapes and sizes about an employee who has potentially been exposed or someone's worried that they've been exposed. Can they return to the office? Can they go to a client site? Can they interact with others? Can they be in a carpool? All, very, very interesting and layered questions, but ones that have become even more prevalent in the weeks and months ahead. Once the shutdown orders get relaxed, the stay-at-home orders get relaxed, the analysis, the next phase, is going to be really determining the suitability of a job for working remotely. And that's a really important analysis, and one, if you have your pens and pencils out, that I would really put a star next to, because it's I have clients that have remote work policies. Some of them haven't dusted them off in years, but now is a great time to kind of look at those fresh and decide, is the job, once we get past this stage of events, really one that's suitable for remote work. My personal view is that the workplace, as we know it, is going to change. I think what I'm hearing from many clients, what I'm reading, is that in many instances, employers are realizing that jobs can be done remotely. That can be cost effective, it can be efficient, it harmonizes with lifestyles and family needs and so forth. And there's going to be a fresh look at that process. So there's really no better time than now to figure out whether a job really is suitable for remote work. And what does that entail? Really, there's a checklist of questions. Does the job have clearly defined tasks? Can it be done productively and effectively at home? Are the structures in place from a data security, from computer systems that would facilitate that type of arrangement? clients' expectations, customers' expectations. Are we managing those correctly? Do they know that employees may be working from home? Okay, and if so, even if we don't need their permission, do we want to manage the narrative to ensure that they're kept in the loop about how things are going to be handled? Okay, preparing for remote work. Again, critically important. You've got issues about the equipment that employees are going to need. The electronic devices. When is someone going to be able to utilize their own, devices, their own phones, their own computer systems to link up with the computer system? As I said before, a huge issue about maintaining data security and documents. Are appropriate steps for confidentiality being taken? Managing the remote work is the related piece of this. For managers, almost regardless of where they are in the hierarchy, it's a different skill set in many respects to manage a remote work employee. The communication is huge. Managers, in my view, and supervisors really need to have a structure. They need to have a regular system of communicating with staff. They need to make sure that employees understand how their performance is going to be measured and evaluated. Employees are going to be held to the same standards of quality and in terms of honoring the policies and procedures. All very important issues to address from a management standpoint. And I can't emphasize this enough. Regardless of the size of the organization, these are challenging issues. The stress levels are quite high, but you want to have predictability. You want to have habits, good work habits that make sense. That means setting up schedules that work. It means not allowing employees to work outside of those schedules for reasons which I'll talk about in just a second without authorization, and making sure that there's regular communication and regular agenda items about what's being discussed, whether the deliverables are being met, and whether this thing is working. And again, it's going to be trial and error, but again, it's fraught with problems if there's not planning ahead of time. A huge piece of the remote work analysis is really the compensation issues, and and that really has two aspects to it. It can involve remote work employees whose work hours may have been reduced from say 40 hours to 30 hours or to 20 hours in light of COVID-19. So for non-exempt employees, the folks who are eligible for overtime, but who are paid typically on an hourly basis, you'll want to make sure for budgeting purposes and other purposes that employees are not exceeding the hours requirement without getting the authorization to do so. Okay, so on a plain, very basic numbers analysis, very important to go ahead and make sure that that's being implemented and followed. Secondly, particularly for, again, non-exempt employees, those folks who are eligible for overtime pay, there are many what are called off-the-clock claims being filed, and claims being filed by employees who say they worked extra hours, but did not report them, but that they should be compensated for them nonetheless. It becomes much more difficult to manage in the remote work situation. You get into very interesting issues about employees taking, responding to emails or text messages after hours, and receiving phone calls after the scheduled hours. Very challenging issue. But the big takeaway here is to track those hours, make sure that the employees, and I'll talk about this in terms of one of the best practices, are accurately and fully reporting all of their hours, that they're encouraged to review their paychecks when they get them to make sure that they're complete, so that we don't have situations where employees are later coming out and saying, well, wait a second, I didn't get paid back in February hours that I thought that I should have received. Liability issues, again, can be very significant. You've got the Fair Labor Standards Act, and the overtime claims that we just talked about. You've got potential workplace injuries and loss of data. And certainly you've got the wrongful termination and the other performance-related claims that can exist. Keep in mind that when folks are returning to the office and there's decisions made about who will be required to return, who can work remotely, that again, there needs to be a legitimate business decision for that rationale, rather, for that particular decision, because those are going to be subject to claims of potential discrimination or retaliation. What do I mean by that? What would be an example of that? Someone who has been working remotely but registers a complaint about not getting fully compensated, and then all of a sudden is told they can't work remotely anymore. Well, that could be the seeds for a retaliation claim. So what are employers to do? What are some of the best practices and what are things to be kind of keeping your eye on? One is insurance. Take a look with your insurance agent, your insurance broker. Do you have what's known as employment practices liability insurance, which is a special kind of insurance for employment claims? For those taking notes, put a little asterisk next to this one. Do you have coverage for overtime claims? Okay, and then one step down, what kind of coverage do you have for overtime claims? Many insurance policies will cover attorney's fees. They'll cover the underlying liability up to a certain amount, okay, and associated costs. In many instances, employers are shocked to find out that if they have coverage for wage and hour claims, such as overtime claims, they may only have coverage for attorney's fees and not for the underlying liability. So really explore that with your insurance agents and brokers. Make sure that in terms of employees working remotely, that there's full coverage and that nothing really changes. In terms of best practices, what I'm going to do is kind of hold off on that piece of it. I'm going to talk about it later when I return to talk about returning to the new normal. Right now, I'm going to go ahead and turn it over to my colleague Mike and for his discussion of various other employment-related issues.
Thanks, Mark. Appreciate it. And thanks, everyone, for joining us. I'm going to just go through briefly some of the issues you need to be considering as you navigate leave requests from employees related to COVID-19. We'll start first with a just an overview of first principles that we all should have hopefully had in place prior to walking into this pandemic. We've on the local level in Montgomery County, we've had the sick and safe leave law now for a few years, and the state came in and passed the Healthy Working Families Act. And if you have employees in the District of Columbia, you well know that there is the Accrued Sick and Safe Leave Act that we need to be mindful of. So hopefully all of you have had policies in place setting forth and giving employees the leave that they would be entitled to under these three statutes. And the Montgomery County one is a statute that's a little bit broader than the state and the Sick and Safe Leave Act in DC, because they had the idea of public health emergencies on the mind when they passed that statute. So there was already coverage in that law for leave related to a public health emergency. The Sick and Safe Leave in the district and the Healthy Working Families Act focuses more so on the sickness of the individual or caring for a family member who is sick. One thing that needs to be kept in mind now that has kind of changed as the pandemic has unfolded at the state and the local level is the District of Columbia passed a COVID-19 emergency act. And the initial act amended the DC Family Medical Leave Act, which had traditionally applied to workforces with 20 or more employees. So for those of you joining us this morning that have less than 20 employees, that have people in the district, this may have never been on your radar, but the district passed these amendments to the Family Medical Leave Act, providing what they've characterized as emergency leave, declaration of emergency leave, And this is unpaid leave under the Family Medical Leave Act. But what is interesting about what they've done is they've reduced the applicability of this statute to all employers. So you don't have to have 20 employees for this leave to kick in. And it basically is unpaid leave related to COVID-19, where a declaration of emergency has been issued by the mayor, and that was issued in March and is still in place, or if there's a government mandate or quarantine or isolation order, which the district is under. So the key distinction here is it provides for the duration of this emergency event unpaid protected leave. So you could not terminate or take an adverse action against an employee who tests positive or who can't come to work because of a government isolation order. Also, following up on that, the council amended that law in an emergency basis, and the amendment affected the Sick and Safe Leave Act, and it equally provided expansive leave. So it expanded the Sick and Safe Leave Act to provide a new category of emergency leave. And the amendments to the DC Sick and Safe Leave Act really followed along the federal Family First Coronavirus Response Act that I'll talk about in a minute. And it allows leave for those reasons that are also allowed under the federal law. And it basically gives paid leave of 80 hours, and it has a part-time equivalent. So a part-timer would have the equivalent amount of leave. But it, interestingly, requires or does not allow for employers to make the leave run concurrent with other leave. And so at this point, the best practice would be to allow the federal leave to run and then also provide a period of additional 2 weeks under the Sick and Safe Leave Act for COVID-19 related reasons. So it's a pretty taxing burden. And unlike the federal act, there are no tax credits baked into this law. That may change later, but currently there are no tax credits linked up with it. So just a broad overview to be flagging that issue, if you've got people in the district. But so overlaying that, those state and local level laws, as I'm sure most of you know by now, the federal government passed a law, the Family First Coronavirus Response Act, and that's applicable. It's in effect from April 2nd until December 31, 2020. Provides paid sick time and paid family time for COVID-19 related reasons. The statute sets forth 6 criteria for when an individual can take the leave. It's when they're showing symptoms and trying to get a medical diagnosis, if they've been told to quarantine by a healthcare provider, if a federal, state, or local quarantine is in effect for them, or if they're caring for an individual who's suffering from COVID-19. And it's got the family component as well. If the child's school or a place of childcare is closed for COVID-19 reasons, which currently in the region that is happening. And then there is a kind of a catch-all as this situation unfolds if the Secretary of Health and Human Services declares additional bases for the leave. And the leave that's available is it's going to be 80 hours of 2 weeks time for sick leave, and also after a 10-day burning off period, there is a family leave component for 12 weeks of leave at 2/3 the employee's regular rate. So it's a pretty expansive program, and it's designed really to ensure that employees don't feel compelled to come to work to get a paycheck. So we've had the benefits since the law went into effect of some Department of Labor regulations, which have helped to clarify some of the gaps in the law. So I'll briefly touch on some of those. There was a lot of questions about what type of certifications can employers be requesting of employees when they want this type of leave. And the regulations came out and basically said that employers can require certifications, documentation, and what the regulations set forth is the documentation should require, the employee's name, the dates the leave is requested, the qualifying reason for the leave, and a statement that they're unable to work because of the leave. So this basically makes it up to the employers to put together some documentation that conforms with the regulation. And so there's lawyers like Marc and I kind of breathed a sigh of relief because we were now able to advise kind of exactly what type of questions you can be requesting and requiring. And for instance, if someone says they can't come to work because they're under a government quarantine, you can be requiring them to identify the government agency that's quarantining them, and things of that nature. Similar on the child care, you can request, identification of the school or child care facility that's closed down, and so that's helpful. There was also an open question of how it would relate to the previously required Family Medical Leave Act on the federal level. That applies if you have 50 or more employees. The regulations make clear that it can run concurrently with Family Medical Leave Act, so it's not an extra period of time. It's just this becomes paid leave, so you would run it concurrently with Family Medical Leave Act, with the Family Medical Leave Act requirement. Another big question that we were frequently getting that the regulations set forth is, what about this idea of intermittent leave? Can this leave be taken on an intermittent basis? And the regulations really shut the door to that, except for in narrow circumstances. And the rationale that was articulated in the regulations basically said, look, this leave is really designed to keep sick people or people that may be asymptomatic but have been exposed to an individual with COVID-19. We want them out of the workforce. So we don't want them spreading it around. And intermittent leave would not conform with that, because if someone's not feeling good on a Tuesday, or they need to be the one to care for a family member on a Tuesday, but somebody wants to come in on a Wednesday, they're just walking right into the workforce and spreading it around. So the Department of Labor said, no, we're not going to allow it in that circumstance. So you can really, it's basically all or nothing for most of the bases for the leave. But if the reason for the leave is the child care is closed and it's not COVID-19 related in the household, then it can be used on an intermittent basis. So if someone needs leave on a Tuesday to care for the child, and Wednesday another spouse has child care responsibilities, if there's not COVID-19 in the household, the individual can use it on an interim basis. Also, the regulations make clear you can, as an employer, allow for the intermittent leave, but it's going to be an agreement between you and the employee. And so just kind of briefly, when you're talking about how you're going to pay for the leave and what is the entitlement, and so on the paid sick leave, employees are entitled to 100% of their normal salary, up to $511 per day, and $5,110 per employee. So that's for the sick leave. The family leave, it's 2/3 a person's normal rate of pay, up to $200 per day, or $2,000 total per employee. So that's kind of some of the issues that the regulations helped clarify, and also some of the common questions that we've been receiving related to Family First. So again, just when you're talking through your leave issues, you want to look at your state and federal and local requirements, look through the Family First leave. That leave needs to run before it. You have everybody your employees use the leave you provide them. Then the Family First kicks in. And then your leave benefits that you may have previously provided, whether it be because of your own policy or because you're following state or local mandates for sick leave, that then follows thereafter. And so you need to kind of look at your own policies and these new and evolving leave provisions when you're faced with issues related to employee leave. So I'm going to talk next, just briefly here, about some issues related to planning for a return, some legal issues to be mindful of. And, unfortunately, one of the issues that people will be facing when they come back to work, and a lot of businesses have already had to do this on an emergency basis, is furloughs, layoffs, things of that nature. But as you return to work and this situation continues to develop and you have a better understanding of what the demand for your services will be, you're undoubtedly going to have to also be considering furloughs, work shares, and layoffs. I'll just touch on briefly kind of what's the difference between the three. A furlough is a period of unpaid leave. It could be on a monthly basis. It could be on an hourly basis. You could take someone who traditionally works 40 hours and bump them back to 30 hours. You could say someone's not going to work for the 4th week of the month. Or you could say, look, we don't have anything for you right now. We anticipate in 30, 60, 90 days, we'll be able to bring you back into the fold. We're going to furlough you on a temporary basis. A layoff is a cessation of employment. It's basically the notion that we don't have work for you. We don't know when we will, and so we're going to lay you off at this point. The key distinction being the furlough, you don't have to pay out leave, accrued leave, if your policies otherwise require it, because they are still your employee. They're just on unpaid leave status, and you, depending on the terms of your benefit plan, you may be able to keep them on your health plan during a furlough. It's very important that you check with your benefits provider first before you make that offer to someone, but it's a possibility. A work share is a little different. It's a program set up by the federal government and adopted by a number of states, including Maryland. It's basically a prepackaged deal with the Department of Labor regarding unemployment. So you go to the Department of Labor, you file a plan of a work share plan. You basically say, we want to furlough this division or this department or our entire workforce, reduce them back to maybe 20 hours a week. If the Department of Labor approves it, they then will provide a proportionate share of unemployment benefits to those employees. But you're taking the burden on yourself as the employer to get it all pre-approved. And so your employees are not left to navigate the unemployment system without some guidance. The expansion of the unemployment through some federal changes has really made this available to the individuals if you do furlough them partially, but they're navigating it on their own. And so this may be an option for those who want to do some legwork for their employees. Thinking it through as you bring them back into the fold, when would a furlough be appropriate as opposed to a layoff or a reduction in hours type furlough? You're thinking long term here, and you're deciding based on how the business is returning whether or not it's realistic to think that you're going to be bringing people back up to a full-time basis or bringing them back into the fold in the reasonably near future. If not, you want to be thinking about layoffs. If you need to right-size your workforce, or if you're just eliminating positions, you might be thinking about a true reduction in force, meaning elimination of positions. So you want to be looking at kind of how the business is returning when you do open and make furlough and layoff decisions. with all of that in mind. While you do that, you need to be laser focused on wage and hour issues. And this is particularly a big challenge for those with exempt employees. Exempt employees can't be furloughed for just a Friday during the week if you think you're going to be reducing their salaries. It's got to be a full work week where the employee is completely relieved of any obligations to do work for you to not to pay them their salary. Because when you're exempt, you need to be getting a full salary. And if you make deductions on a part-time basis for that, you'll be jeopardizing the exemption and subject to overtime claims. So really be careful if you're furloughing exempt employees that you're just really shutting them off and not having them do any work for an entire work week. Other issues to consider while you navigate these challenges are WARN Act issues. If you're on the call and you have over 100 employees, you really need to be mindful of the WARN Act, particularly the farther away from the immediate shutdown we get. There are emergency exemptions to the WARN Act for unforeseen events, which I think most people looking at this have determined that the immediate shutdown would have qualified for one of those issues, one of those exemptions. But the WARN Act really requires 60 days notice if you're going to do a layoff or a group layoff. And so the further we get away from the emergency, the more likely it is that the WARN Act could have implications for you. So you just definitely need to be mindful of that. There are also now, if you've applied for and received the Paycheck Protection Act money from the federal government, there's legal implications here in terms of your head count. If you're going to be going for forgiveness, the June 30th date is going to be something you need to keep in mind. You want to be thinking about the PPP issues. The regulations have made clear you can bring them back on board. As you get closer to June 30th, you've already furloughed people, you've already laid them off, and there's going to be additional guidance on the PPP and the forgiveness components that has yet to be issued. So be watching for that. But these are just some of the issues that undoubtedly you're going to be facing as your, the business gets restarted and your revenue streams you start, and you have a better sense of how revenue is going to return if it's going to be short of where it was. Work shares, furloughs, and layoffs are things that everybody should consider and keep in mind, these very important issues. Another big one that we're all going to be facing is kind of current and future accommodation issues under the Americans with Disabilities Act. The ADA, it's got a number of facets to it, the Americans with Disabilities Act, but you basically, you need to be making reasonable accommodations decisions for someone's disability. How can we alter the work environment to accommodate somebody's disability? What's reasonable? What's going to be required? It's important to be thinking through these issues now. There's no reason to wait. If we are all here in a remote work environment, but we're anticipating coming back into the office shortly, we want to be thinking about how we're going to do that and how it's going to relate to the ADA. One component of the ADA prohibits employers from making medical inquiries. And so, how restrictive is that going to be in the time of this pandemic as you return to normal? Asking about symptoms and exposure to COVID-19, all the relevant agencies have said you can do that in this pandemic environment. So what is it that you're going to be requiring of your employees in terms of what they need to disclose on a daily, weekly basis in regards to potential exposure or symptoms to COVID-19? Temperature checks. 2 months ago, when we all lived in a better world, this was really a no-no in almost all circumstances. But now, once again, the CDC, the EEOC has made clear that you can take temperatures in this pandemic situation. So we just you need to be thinking about, are we going to do that? Are we going to require people to do temperature checks on the way in the morning? Thinking through public health information that suggests that kind of a temperature check is a lagging indicator of exposure. People can be asymptomatic and be spreading it. So does that really give you the bang for the buck? That's going to be a determination businesses are going to have to make. Protective gear and reasonable accommodations regarding protective gear. I mean, in normal times, protective gear would be something that somebody who has a disability may request a reasonable accommodation for, and you would do the typical analysis. But as you've seen if you've read some of the news reports regarding, meat processing plants and how COVID-19 has spread rampant in that tight quarter environment that's closed in, there are OSHA issues regarding protective gear. So not only are you thinking under the ADA, what do we have to provide to people with disabilities? And remember, the ADA is only going to apply if somebody has a disability. So it's not going to be requiring you to provide accommodations to people without disabilities. But there could be OSHA-related issues, because you have a duty to provide a reasonably safe work environment. And if your environment is such that people work in a bullpen, everybody's right on top of each other, do you need to be spacing them out? Do you need to be putting up plexiglass dividers between people? There's no right answer for all workplaces. You're really going to have to be looking at those on an individualized basis and making those determinations. And so forethought now is really critical as you think it through. And also, if you know people in your workforce that are working from home now have disabilities, you've already been on notice, they have accommodation plans, reach out to them at this point and see, assuming we get back to normal, what type of accommodations are they going to be requesting, and work with them to have that in place now, so you're not scrambling later when we all get the go-ahead to resume business. I know I did a lot in a short period of time and I moved quickly, but I'm happy to answer any questions anybody may have offline about specific issues. So with that, I'm going to turn it over to Marc to talk about some other implications regarding returning to normal and things you should be thinking about.
Okay, thanks, Mike. It was really a terrific overview of some pretty tricky issues. So let me try to move into the last quarter of the session here today by talking about kind of returning to the new normal and hopefully providing a list of some actionable items that I think are going to be very effective, provide a lot of high value to try to move forward. I get it, Mike, and I get it. There's almost a wave of information that almost makes your head hurt to try to think about all these different issues. The news flashes, it makes our heads hurt as well, maybe not to the same degree, but what we're trying to do at the firm is really synthesize information and present it in a way and make it available in a way that's digestible, that's actionable, and that's going to yield benefits. So what all of you are going to have access to, thanks to our terrific colleague Scott, is the materials from this webinar, and included among them is an article that I just finished on 19 considerations that or measures that employers should consider in light of the COVID-19 pandemic. And so I'm going to go through a bunch of those now, but they're going to be in an article, and they're going to be maybe easier to follow in that format if you prefer that fashion. But before I do that, let me just put a fine point and kind of elaborate a bit on a couple of those excellent points that Mike made. In terms of OSHA, there are going to be obviously requirements about when and under what circumstances it's safe for employees to report to work. OSHA has come out with it's about a 35-page guide for employers on returning to work. If you'd like that, a copy of that, let us know. We have a lot of materials up on our coronavirus center. I'm not sure if that link is there, but if you'd like to see a copy of that, I'm happy to send that to you or make it available to you. It's a very nice overview of what employers should be thinking about in terms of best practices. In terms of the PPP, which Mike mentioned, there are kind of nuanced requirements for maintaining headcount on the employee side, when you do it by. It's a longer discussion, but we do have some excellent materials that our partners have put together on our coronavirus webpage. I encourage you, our colleagues have gone to great lengths to try to break down those tough issues and use that, please, as a resource. The other things that I wanted to share with you is that, Mike talked about a number of the best practices, policies, and so forth. Before I forget, and we run short on time, if any of you are looking for example, a list of interview questions, a list of reference questions, evaluation forms, which still need to occur, or even the form for folks taking leave under the new federal paid leave statute, please send us an email. Send me an email. I'll make sure you get those at no charge. So let me kind of pivot into, okay, what can we do in the next few weeks or next couple of months and dust some things off or create some things that are really effective and helpful. Number one, really be thinking about an emergency paid leave and family leave policy that complies with the new Families First Act. There's some new requirements, as Mike mentioned. Again, I won't go into all of those, but it's a good idea to have a policy that explains to employees what you need to include. More generally, even apart from the paid leave, it's really important to have a remote work policy. I realize some folks have them, some folks don't. Some folks didn't think they needed it, but I think it's a really important best practice to have one of those. It doesn't have to be, 5 pages long. It really needs to really set out that it's in most instances a benefit, not a right. It needs to provide some of the basics about how the remote work arrangement's going to unfold, what the criteria are, and what the expectations are. I think the mere exercise of going ahead and putting one of those together is going to be incredibly helpful in terms of saving hours and hours of administrative time and time that you're going to have to spend answering questions about how this is going to unfold. And also to give you a blueprint for when and under what circumstances folks can continue to work remotely as we move forward. I talked a little bit about, updating and looking at your insurances. Again, I'm going to sound like a broken record. Please take a look at your insurances with your agent, your broker. Ask her or him very simply, am I covered to the same degree as I was for folks working remotely? And by the way, what else would you recommend that I include in my insurances that I may not have? What's it going to cost me? Job descriptions. If any of you have heard me speak before, you know that I'm a huge believer in job descriptions. They provide the rules of the road of engagement. They help manage expectations. They provide the foundation for performance evaluations. They help employers keep from getting sued or having claims filed or unhappy employees who go out on social media. It's a good way to manage expectations. Really important if the job description is changing, to update an offer letter, update a job description to reflect that. Another thing to keep in mind, Mike talked a lot about the notice periods for different leave statutes and different things that you need to be mindful of. Keep in mind that in Maryland, if you're going to be reducing a wage, which is pretty broadly defined, you need to give 1 pay period's notice before that becomes effective. Okay? As you're looking at the jobs and job descriptions, please take a look and say and ask yourself, am I characterizing these folks properly as exempt or non-exempt? It's a very understandable and common error for folks to think that simply because someone's on a salary, they're automatically exempt. To use a baseball analogy, and we all can't wait to go to a baseball game again, That's just that's getting to first base, is the salary piece. It meets the statutory requirement. You also need to satisfy what's called the duties test, to make sure someone either falls within the professional, the administrative, or the executive exemption. A long-winded way of saying, am I characterizing my employees correctly? Hugely important going forward. What else can we do now that's really going to be effective and a high return on investment, so to speak? Train managers. It doesn't have to be 7 hours of training. It can be snippets of 15 minutes and 30 minutes and 45 minutes of best practices for training employees. The inside baseball, to use my baseball analogy, is that many managers, particularly for some of you who are larger size employers, they are reticent often to come forward and acknowledge that they don't understand or they have questions about how to manage somebody effectively. They don't want to seem, unknowledgeable or foolish. And that's a prescription for a headache and claims and all sorts of issues. So train those managers, even if it's, 10 minutes a week, okay? And if you build on that, and so you have an environment where managers are coming forward and asking questions. How should I handle this remote work employee? This person wants to come back to work. They've been quarantined. What do I do? Much, much better to address that ahead of time. Establish gatekeeping procedures. Hugely important. What do I mean by that? If someone's been exposed to COVID-19, they have a family member, they've been quarantined, you want to have a person, usually it's the HR person, but for those of you who don't have HR managers, it's somebody who's wearing 17 hats to make sure that somebody's checking in and making sure it's okay to return to work. You don't want there to be a disconnect and find out, gosh, I didn't know that person was coming back. And then you've got contagious issues and a lot of other problems that could have been avoided. Employers, as Mike talked about, can require a note to return to work from a physician or a healthcare provider. And again, my advice on that is to err on the side of safety and health first. Yes, there's a whole lot of ADA issues and things like that, but by and large, we're trying to put safety and health first, and trying to have appropriate employment measures that follow behind that. If need be, depending upon how long the stay-at-home orders, continue, if folks are deemed essential, create a letter to them so that they can have it with them. If they're traveling about, we don't want those folks getting picked up and having to answer for that. So Mike and I have both created forms for letters to give to employees that addresses the essential need for their work. But again, be reasonable and appropriate about how you're defining what it means to be essential. You're going to want to start thinking about establishing workplace policies and procedures that comply not only with the government requirements for returning to work, which I understand are going to be rolled out soon, relatively soon, but also being mindful of what the OSHA requirements are at work so that we're doing this correctly. There's going to be more information. I think our working with business owners on other aspects of the return to work. So, if you want to make a note to kind of follow up, on the coronavirus center, we're going to be having, no doubt, more materials and information about that. If employees have confidentiality agreements or they have some sort of non-compete, again, this may be a little bit more forward thinking in terms of where we go, but you're going to want to think about revising those to reflect sort of the new normal in terms of how business is being done. Okay. Again, non-competes are looked at, which is the pure, you can't go work elsewhere, are looked at very critically by courts, and especially so with so-called wage earners. There's a Maryland statute that deals with that. But things like non-solicitation of employees, non-solicitation of customers, you're going to want to be more careful about how those are worded and how it's going to apply in this sort of new work arrangement. perhaps most importantly, from the confidentiality side of things and protecting trade secrets, really work with your IT folks. That, think about password protecting documents. Think about restricting access. Protect your customer lists. Again, this is not my field. I'm not an IT person, but again, work with your IT professionals to come up and try to protect that information to the greatest extent that you can. Last, but by no means least, is really prioritize employee engagement. No question that remote work arrangements can alter an organization's culture, but if you have regularly scheduled communications, you have clarity in assignments and expectations, you encourage feedback from employees, and you have meaningful, formal and informal these days, job reviews, all of those things are going to promote a healthy and effective and efficient remote work arrangement and a return to the new normal. In closing, before we open it up for some questions, there's obviously, we understand a lot to digest. We're going to continue at the firm to search for ways to, as I said, synthesize this information, put it in a format that's actionable, and provide you with concrete steps that you can think about taking both on the employment side, but also the PPP side and other things that affect your businesses. So with that, I guess I want to turn it back to Scott, I think, is the next order of the day for some questions, and then we're going to be available for a few minutes after the presentation piece for some additional questions. If any of you have, any of these forms that I just mentioned, the evaluation forms, the interview questions, the reference questions, the letter to give to employees, if you're interested in obtaining copies of those, please let us know. Back to you, Scott.
Absolutely. Thank you, Mark. Okay, so we will, like Mike and Mark said, we will be circulating their contact information and some handouts along with a recording of this presentation. I know that there has been some issue with the quality of the recording from some people, so the recording has sounded great on my end. Hopefully, the file will fill in any blanks if you had any. All right, so we have a few questions. Thank you to those who submitted ahead of time and those who've submitted during the presentation. The first one I'm gonna kick to Mike. It goes: the regulations are that employees who are furloughed must be brought back by June 30th. What happens if their job distribution and what programs are possible? We are a nonprofit, may be in conflict.
Yeah, thanks, Scott. So I think the regulations are such that the June 30th date, what's been published so far suggests you can bring them back by that date and still include them in your head count for a forgiveness analysis. And there will be more regulations to be issued shortly on exactly how the government's going to look at the forgiveness. Understanding that if they can't come back because maybe they don't want to, they moved on, or you can't bring them back. I think what I've been telling folks is, the loan terms are very favorable. So to the extent you cannot get complete forgiveness and you can only get partial because of that issue of not being able to bring the whole workforce back, it'll be, the loan term is not very oppressive. But just long-winded way of saying, I think we'll probably get more clarity on that when the regulations come out on forgiveness.
All right, great. And this one's from Mark. We have a small office, tight space to move around. How will we figure out when it is safe for employees to overlap during work hours?
Yeah, it's a great question. Thanks, Scott. So I think the answer to that really has several aspects. First, I think, employers are going to need to follow, obviously, the requirements are going to be what I think are going to be imposed by the governor in terms of returning to work. I think there'll be a phased-in return, and there'll be certain requirements, I suspect, about what employers need to do to comply with that phased-in return. Secondly, I mentioned the OSHA requirements. The OSHA does have, the guidance that talks about return to work and best protective measures depending upon low risk, medium risk, and high risk employees. And I think that'll factor into the analysis. Third, I think the CDC is going to no doubt be issuing guidance, continuing guidances about social distancing, both in the workplace and otherwise. I think it's going to involve, kind of looking at the space, determining how many employees can return to work and work at a safe social distance. That may in turn, I'm hearing clients that are rotating schedules, folks coming in at certain times and staggered shifts. So I think it's going to be a very individualized review. I do think that for employers who can work with consultants, even if it's for an hour of their time, who are, well-versed in, industrial office issues as they pertain to the workplace and best practices for safety and well-being. I think that's an incredibly important thing to consider as well, because if you get advice from a professional and you act on that, I think that goes a long way to establishing that you took the appropriate measures.
All right. And it is noon now, so if you have to drop off, we understand, but we're going to stick around and answer a couple more questions here. So we appreciate your patience if you're sticking with us here. This one, I'll just either Mike or Mark, whomever wants to tackle it. This one's about telework. And the question is, if we tell employees not to check emails or calls on evenings and weekends, could they come back and say that we owe them for hours if they did work outside of work hours?
Go ahead, Mike. Yeah, please.
Yeah, so this always has come up even before this issue. An employee can always claim that if they have the access. So if there's no technological way in your system to shut off the access in the evenings or on weekends, then you want to be clearly instructing them not to. And the issue, if such a claim is made, is whether you knew or should have known they were doing it. And if that's the case, then you can be found liable. So, for instance, if you tell them not to do it, and you're the supervisor or you have supervisors, and they are receiving emails on nights and weekends, that's going to put them on notice. And similarly, if you do a read receipt and the employee opens up the email and you get a read receipt back on, in the nights and the weekends, you're now on notice. So my preference is to find a technological way to turn that function off. If not, you got to train the managers to make sure that if they become aware of it, we got to take steps to stop it. And also you may want to consider making sure that you're preserving the records to the extent there are any of online use on the back end with your IT folks, in case you need it later if a claim is made. If you're able to point to those records and say there was no activity on our system for that individual from certain times, that could be helpful. So you're not off the hook just because you tell them no. So you got to be mindful of evidence that would suggest they are checking on nights and weekends.
Yeah, as to that point, I agree with everything that Mike said. I think the advice is spot on. One thing or two things that I've done to try to, in addition to what Mike discussed, is create something called a timesheet certification. It's just a one-paragraph form that I'm happy to make available to folks. It basically says, I, Jane Smith or John Smith, represent to the company that for this week, I have fully and accurately reported all the hours that I've worked, right? And it's got a little grid for each day of the week. And that no supervisor, I understand that no supervisor is authorized to instruct me not to record all the hours that I worked. And I know that the company is relying upon the accuracy of this certification in compensating me. Why do I want to have that form? Because I want to be able to show that each and every week the employee had to sign off that she or he is truthfully reporting the hours worked. Okay, and so as Mike said, Mike's absolutely right for all those best practices, but really want to put the onus on the employee to come back and be forthright with those hours. If somebody has worked a few more hours than we knew about, or we should have known about, you're going to err on the side of paying it, but then on a going forward basis, you're going to make it crystal clear that you don't want them working those additional hours. Secondly, there's a form that I've created. It's kind of used during the orientation phase, but we use it other times. It's kind of a 3/4 of a page form that basically it's an acknowledgement by the employee about what the overtime rules are and working outside of regular hours. And it includes, again, an explanation about what they need to do in terms of before they work overtime or outside their regularly scheduled hours. And again, the rationale behind it is that if someone comes back later, 5 months from now, 3 months from now, and says, I worked all these additional hours I didn't get paid for, you're going to have the documentation that said, why did you sign the acknowledgement? And didn't you certify each and every week that the hours were correct? I mean, Mike and I had a couple of years ago a case, I don't want to sound too cynical, where somebody claimed more overtime hours than that person could have worked in a year, I think, Mike, if I recall correctly. So we're seeing a lot of these so-called off-the-clock claims, but I think there's some really effective strategies that can be implemented to try to make sure everybody's on the same page.
All right, and final question then. If I furlough staff versus termination, do I need to pay out their accrued vacation? Do I need to allow them to take accrued sick leave before I furlough them?
Go ahead, Mike. I think you were touching on that before.
Yeah. So when you furlough them, you don't have to pay out accrued leave. So in Maryland, you have to pay out accrued vacation unless you have an agreement at the beginning of employment that says, and it's in writing, that says we're not going to pay it out. So assuming you traditionally pay it out, if you do a layoff, you have to pay it out because that severs the employment relationship. If you do a furlough is a period of unpaid leave. It doesn't sever the employment relationship. So you do not have to pay it out. What I've been telling folks is it may make sense to do so if you can't bring that person back later, because it is an obligation on your books. So if you ultimately decide you can't bring them back and you terminate the employment relationship, you're going to have to pay it out later in a lump sum. So it might be better for you to allow them to use the leave to burn it off during the furlough period.
All right. Very good. Well, that will conclude our webinar. Thank you again to Marc Engel and Mike Neary, and as well as to our co-sponsors, the Greater Silver Spring Chamber of Commerce, the Greater Bethesda Chamber of Commerce, and the Gaithersburg-Germantown Chamber of Commerce. Have a great weekend.